we have secretary.
Secretary, yes.
Yes.
So we can go for secretary.
Secretary,
Very
yes.
well, my lords.
And we have very, I think all of us have very pleasant experience of
Pragya.
Pragya. She has done a very commendable job.
Amazing, yes.
Absolutely.
Amazing, yes. So secretary can be one, it can be treasurer or joint treasurer, whatever your lordship.
As your lordship sees fit, my lords.
Dr. Mayank, you were saying something?
No, my lords, as your lordship sees fit. Secretary, treasurer, maybe both positions.
SCB is started with treasurer. SCB is started with treasurer.
One or only two?
2+2 will be better. It may be that they will normally get elected also, but
Then joint treasurer can be.
right?
Very well,
Very well,
very well.
very well. And 2 posts in the executive members.
And 2 executive.
Yes, ma'am.
Say the issue pertains to ensuring adequate representation to women advocates on record in the composition of executive committee of office bearers of executive committee of the Supreme Court Advocates on Record Association.
Don't know the day.
Both sides have graciously and fairly, on our suggestion, I agree that in the ensuing election of SCORA, the post of secretary and joint treasurer and 2 executive members may be earmarked for representation of the women advocates on record.
Yes.
Can say, invoking our powers under Article 142 of the Constitution, we ordered a court.
Yes.
Now we are happy.
The time they
We are
will.
happy now.
Minutes,
So
the
the-
larger issues were involved, minutes, because then minutes may also would have considered at the level of entry also minutes. The question of these are the larger issues in context of only AOR's minutes I was submitting.
All right, all
As
right.
So
minutes-
saying whether there's a
as
requirement to extend the time or SCORA will be able to do it in this time
The
frame.
schedule remains the same.
They can do it.
They'll do-
Remains
all-
the same. There's no problem, my lord.
All right.
Minutes can be-
Yes,
Yes, yes.
absolutely.
Nomination is anyway
Grateful.
starting from 15th April
So
until
Yes,
20th.
no difficulty. I just wanted to inquire. Grateful to your lordship.
We're also very grateful, my lords.
thank you
Yeah.
very much.
Give your way.
Like,
Lords, 57, Lords, I'm only aggrieved with the non-grant of stay insofar as the proceedings are concerned, and I'll tell you, Lordships, why.
Item 57.
57, my Lords, this non-grant of stay, my Lords, is my only worry, and I'll tell you, Lordships,
What?
why.
We shouldn't entertain this kind of.
No, I'll tell you, Lordships, why, my Lords. Lordship may kindly see, after the FIR gets filed, there is a closure report that comes to be filed by the CBI. While, my Lord, setting aside the closure report and order further investigation, Lordship may kindly see what the order passed by at page 206. Lordship may kindly see. 206 says, my Lords, that insofar as this entire final report is concerned, it does not say and it does not adhere to the order passed by the High Court while transferring the matter to CBI, which says, please find out the gamut of the so-called scam insofar as the number of people who could be victims. CBI makes a specific, my lords, argument saying that we could not find any single victim insofar as this company or the scam is concerned. My lords, the chief,
The state of Mizoram is the biggest victim.
my lords, and that,
The state of Mizoram is the biggest victim.
my lords, and my lords, that is the
The public servant to swindle away the name of the state to permit a criminal to perpetuate multi-level
My
murder.
lords, but that is what the CBI says has not happened. When it filed
You
the
want us to write all these things in the order.
no, my lords, I am only requesting, my lord, lords,
Privilege petition dismissed. The moment we will write 2 lines, it will become problem for you.
Lordship, I have
Just
compiled a
consider-
brief note for your Lordship's perusal. Madam, I would request you to please pass it on.
See, Mr. Diwan, probably you were not there last time. There was just only very preliminary observation being said. Not prima facie, only preliminary observation. Now this IRP will is under cloud. Whatever may be good reason.
I have nothing to say on that, but I have something to say on the other aspects. Because we received a copy of the report which was made only on Saturday. And this Saturday, after the order came to be passed, we were not aware of the application being made, etc. So I am just, I don't want to get into it. First of all, I have indicated to I'm not saying anything at all as far as the IRP substitution is concerned. Please go ahead with that. Because if there's a genuine problem on that. But on the rest of it, we have something to say, which is why we filed an application for, which we've served on the amicus, for recall, so that your lordships can then adjust the equities, etc. appropriately. So I'm suggesting, I mean, we can do it today, but if they want some time, then on with regards.
Response is ready, you can give, you can keep it.
Yes, yes, I have a solution. This is my recall application.
President, we may examine this response also.
Do that.
Can I take 1 minute, Malord? Malord, we are appearing for one of the banks, IFC. I'll just take 2 minutes. Malord, your lordship's earlier order classified the entities into two broad buckets. NBCC, unfinished projects as one bucket, and finished projects as another bucket. We are a case where, Malord, our project is completely, it is operational, it is functional even today, and there is a default. We don't have any problems of construction or a home buyer, nothing. It's all working. Only problem is default. So, my lord, this is, my lord, as originally conceived, a separate CRP, CIRP, or C, whoever can be occupied to do it. I'm the only financial creditor. I hold 85% stake in the COC. So, what has happened? Earlier order, your lordship directed us to go to NCLAT, which we have done. Our IA is coming on Friday. But day before yesterday's order, my lord, please see one paragraph your lordship may see. Paragraph 4 and paragraph 5. Which, my lord, if we can show only one suggestion, very respectfully, your lordship's kind consideration. Your lordship sees paragraph 4. May I read only paragraph 4 and 5, my lord? Although, as this is pointed out by so-and-so learned senior counsel, the IRP has challenged the suspension order before the Delhi High Court. It seems to us that the projects, meanwhile, must be completed under the court-monitored action. Proprietary demands that the IRP, till he is fully exonerated by the court or any other prescribed authority, should distance himself from the ongoing proceeding. I am appearing for the IBBI in the Delhi High Court against this IRP.
At your instance, that
And we have filed an appeal before the Delhi High. They filed a we have responded. We therefore find merit in the recommendations made by the learned amicus that a court-monitored mechanism be adopted to ensure the completion of projects by NBCC takes place without any hindrance. Paragraph 5. At this junction, we hasten to note that there are approximately 30 projects undertaken by the company in question, out of which 16 have been entrusted to NBCC for completion by way of judgment dated 12/12/2024 and order dated 5/2/2026. In our considered opinion, the issues relating to the remaining projects also ought to be administered within the same court-monitored framework. Accordingly, the underlying policy with respect to all projects, whether fully completed, substantially or partially completed, or which are lying incomplete and inactive, including those which have been handed over to NBCC, shall be determined by a common authority that may be set up by this court. Not 5 of them form one cluster. There is no difficulty at all. Substantially, partially, incomplete, or inactive, they all form. We have, our projects are totally completed and it's operational, it's functioning, and yet default is happening. So we are moved an IA before, as per your lordship's previous direction, earlier direction, we have all been asked to go to the NCLAT to fight our rights. We have filed our IA. It's coming up on Friday. So can completed projects alone be taken out of this list? One of them, my lord, they form a one class. There is no difficulty.
No, we have something else to say, because if it was original appeal was confined to 16, our respectful submission is that it ought not to be expanded to 30. I don't know what he might. I'm not for a moment opposing what is being suggested just now. But suddenly from the scope, because the balance 14 projects are pending before NCLAT. They are pending. They were not the subject matter of the original appeal.
this was only during the course of very brief hearing.
Yes, brief.
This was our idea, because if 16 projects under a court-monitored committee continues and those projects are completed, or the home buyers in those projects are to their satisfaction able to achieve their and the other projects are maybe that's why we use the word partially incomplete or substantially.
Manoj, but please hear us on this, because it was not the scope. Your lordships disposed of the appeal. Now everybody is before NCLAT.
I am
Now,
appearing
all of a
for
sudden
the home buyers, Millard.
The MA is
Appearing
not
for the home
served.
buyers.
Millard,
2011.
I take serious objection. The MA ought to have been served on every party. That's the least which the amicus curiae must do. The second is that at least he must serve us a copy of the report. Without having a copy of the application, no notice served on an MA, a report filed, served on me after the order is passed. Your lordships have used the expression, in fact, over here, which speaks about propriety. I would respectfully submit that propriety at a minimum requires that in a disposed of case, when a miscellaneous application is filed, at least it must be served on the parties along with supporting documents. That's the least.
No, supporting documents is, it's not, everything is admitted on report that IRP has been found guilty of something.
No, it's not, Millard, I'm sorry.
Placed under suspension. Now the committee which has been looking after the apex committee is headless. All these are matter of report.
I have no problem with that. I started by saying that, look, if there is some practical difficulty, in fact, what ought to have happened in a situation is go to NCLAT and get it substituted by NCLAT. How do you, in a dispose of appeal, come over here, file a report, don't serve it, and secure an order like this, which is a tremendous variation.
No question. You see, amicus has no interest in the matter. There is no question of any securing order by him. This order is only because he pointed out this suspension part to our information.
So that may be retained, my lord. Para 4 may be retained.
By virtue of the approval, we granted to that order. Therefore, because by virtue of an order passed by us, if a person whose conduct, unfortunately for any reason, is under cloud, that's why that there has to be a court monitor.
So, my lords, on that I started by saying I have no problem, but please confine it to para 4.
Yeah.
Lord, may
Consider it.
Yes.
Yes,
may
also
just
projects
make one
have a problem.
There is a submission, Millard, for the home buyer. The submission is this: we are equally placed, other than 16 project, Millard, and these projects are also 2010-11. They are incomplete, and your lordship had rightly said, yes, Millard.
Agree was that 16 projects which we are giving to suppose the court monitoring committee, those projects will be completed. Part of the home buyers will be happy. Rest will be again made.
Exactly, Millard.
But on
I
that, there's no
propose
problem,
that
my
we
lord.
support it, Millard.
That there's no problem. 16 was what the scope of the original appeal is. If someone wants to increase, your lordship appointed the amicus to assist the NCLAT proceedings. Now over there we will have our day in court and we will assist over there. So any variation to be done because of exigencies, etc., can certainly be done before NCLAT. But suddenly to come over here, expand the scope beyond the original appeal.
NCLT is not going to regulate our proceedings.
Correct.
No, of course not. But your lordship disposed of the appeal.
That is the court initiative only to bring
Other than
parity among all the home buyers.
Correct.
And to ensure that some of them.
So I can just use ChatGPT, right? Why do I have to attend your workshop?
See, that's the biggest misconception.
The remaining projects.
3 projects where everything is complete.
No, they are not completed projects.
My case, don't mix up.
But
Not
I
in my
have
case,
one-
I can say it on an affidavit, complete project.
We find a merit even in complete projects. Suppose the financial institutions are yet to recover. Now,
No, so that can be worked out before the NCLAT, because that issue which your lordship is correctly placing before me is actually pending before NCLAT. NCLAT itself had 17 on one side, out of which one is completely complete, so that was not part of the 16 which your lordship held. And then you had the balance projects. That issue is under consideration of NCLAT.
that said, there may not be a ground for us to have to now just ignore the ground reality that's going to happen. If
There is
suppose
no
that
ground reality, my lord.
IRP was there, then this issue was not there. Because IRP was there and it was IRP for the entire company, for the entire entity he was there.
No problem, my lord. You can, as I said,
For the
if there's a
16
substitute IRP, we have no problem with that.
problem.
Lord,
We have no problem with that.
may I just bring one fact to my lord's notice? Mr. Just one minute. Lord, a financial creditor in relation to the 16 projects, my lord, where the apex court committee was constituted and where your lordships, my lord, have noted that IRP is now suspended. Lord, we appear for the financial creditor. The composition, my lord, that was determined by NCLAT, which your lordships found favor with, was total 5-member committee, IRP who now goes out. There are two largest creditors. One was NDCC, fourth was an independent person. Lord, all the other persons are still there. But this committee has done considerable work. Instead of having, my lord, a completely new committee, if the IRP goes out, any judge or any person your lordships thinks appropriate can replace the IRP.
We will appoint an independent committee with some of the ACC. There is an apparent conflict of interest also.
Apex committee.
If you are there, you have
But
to-
then I have only one request. If your lordships are inclined to appoint a completely fresh committee, my lord, my only request is, like your lordships were pleased on the last occasion to give representation to the creditors. Your lordships gave us 2 seats, my lord, out of 5. My lord, I am requesting, my lord, that your lordships may, my lord, appoint any new committee will be with your lordships completely. I am only praying, my lord, let the financial creditors continue to have that representation.
And the home buyers also.
I have no difficulty.
You see, financial creditor, in any case, their interest we have to be protected, and I think earlier orders are there adequate enough. We can,
My lord, only thing that happened.
all directions, we can.
Only thing that happened, my lord, in the committee, my lord, as proposed by the learned amicus, which is, my lord, following what happened in the subsidiary matter. My lord, none of the creditor representatives are inside the committee. So what happened is all our suggestions and inputs are now externalized. If you are a part of the committee, my lord, when the committee itself is considering, there will be an internalized input that would come.
Our experience of appointing independent committees in some of this kind of projects has fortunately been quite satisfying. We will not say that it has been very really outstanding achievements, but wherever in certain other projects such committees have been constituted, at least home buyers' interest has been adequately.
Correct.
Financial institutions' interest has also been to some extent protected, and there is at least no sense of insecurity created as far as their interest is concerned. So we are quite.
My lords are right, but if you may just bring to my lord's notice, just a minute. My lord, if you may bring to my lord's kind notice, what happened is, my lords are completely right, my lord, I respectfully bow down. But in some of the committees, my lord, what happened is where the creditors' inputs were not considered at all, there are litigations now coming before this honorable court. All that I am requesting is, lordships may have home buyers representatives, if, my lord, that is a request that is being made and if it appeals to my lords. My lord, your lordships may only provide, unlike the Supertech realtors, my lord, where none of the creditors' representatives were on that particular board, lordships may kindly have representation from the my lord, creditor side also, like your lordships were pleased to do in this very matter on the last occasion.
That part, once we constitute the committee, will pass an order in open court only.
Because, my lord, para 6,
Mr. Diwan has filed some objections, Mr. Khan, we may consider those.
in para 6, yes, my lord, in para 6, your lordships were pleased to.
We've heard a recalling.
Because we have traveled substantial
Certainly good.
distance. Most of us we have taken.
The word substantial creates problem.
No.
If you say,
We are saying full. I'm saying full. It is operational. It's working and they are defaulting.
if you say the.
In spite of working, they are defaulting.
We will happy a statement if you say project complete, home buyers possession delivered, financial institutions paid, transfer, sale deeds have been executed, conveyance deeds are.
Sale deed registration. Sale deed.
But yes, we are very happy.
Not in my,
What was that
not in my case, no home buyers are involved. It's a mall cum hotel, completely functional, and they are defaulting. Therefore, my lord, can I move an IA? Might be permitted to move.
Because the details of all those projects.
Yes,
are very-
we'll give it.
Like to-
Maybe,
have to examine.
Lordship, in your order dated 5th February, your Lordship, para 20 states that the amicus may approach this bench in case there is any impediment to the implementation of your Honorable Court's order. Consequently, once the IBBI passed the order against the IRP, there was an evident impediment in the implementation of this bench's order. Hence, I move that petition. At the same time, your Lordship, you need to factor in this, that Supertech is a legal entity registered under the Companies Act. It's a corporate debtor. It not only has projects, it has other things. It has investments, for instance. It has subsidiaries, over 24 subsidiaries. It has litigations. It has relational party loans and transactions. All those would need to be taken care of by an entity. Currently, what do we have? Currently, in the absence of IRP, we have nothing. If we agree to the proposition that it is only, if ACC is only for the 16 projects, then who looks after the rest of the company? What happens to the surplus of non-16, or say a receivable from a subsidiary? Who manages the boards of the subsidiaries? There are issues which the company as an entity has to handle. There has to be a credible body like the board of directors, discharging the functions of the board of directors, If not ACC, then who? So in the current dispensation, there was no COC, sir. And if ACC is only looking after 16 projects, then who's looking after non-16 and rest of the company? Only the IRP. I'm sure that was not the conception of the Honorable Bench. So the company has to be looked after. The company's interests go far beyond 16 projects. And home buyers we need to put in a structure in place that protects the interests of the home buyers and then the lenders and the authorities.
Anyway, we'll put in our objections in 3 days' time, and your lordship may list it next week or whatever.
Yes, also you can give your.
Yes, my lord, we will also.
But even on the composition, my lord, we'll place our submission.
Take it on next Monday then.
Yes, very well, very well.
But even on composition, my lord, we'll place our submission. Your lordships invited it at para 6.
Lordship, may I make one request?
Can it be next Friday, my lord?
Lordship's notice just that I may failing in my duty to inform that there has been an amendment in the code, my lord, on 5th of April 2026, and the new guidelines have come on 7th of April 2026, which the amicus is not aware of it, and probably he did not be informed to the court also, my lord. Lordship may appoint the IRB, but that amendments have to be taken into consideration because it has now come as a project-wise, my lord, not independent, not as a composite, my lord. And somebody in grieved out have to go independently to the NCLAT, my lord, not like in a cluster.
Lordship, project-wise committees have not been formed so far.
This is the amendment, my
In
lord.
the NCLAT's order of December 24, the project-wise committees also had a role in finances because the NCLAT stated that the ACC has to conform to RERA regulation of apportioning the funds into 70-30 ratio, wherein 30 would meet the dues of the lenders and the authorities. However, this honorable bench ordered that first, the project has to be completed, home buyers' interests have to be met, and only subsequently the surplus has to be diverted to pay the dues of such and such. Now, so the project level committee no longer have a financial role. And the project level committees have not been
You
constituted.
have a separate committee for each project because.
At the same time, sir, since projects are spread in different places and the lenders are different, the home buyers are different, in some cases the authorities are also different. And the Apex committee may not be physically capable of supervising the implementation of the NBCC project at all the places or monitoring the grievances of all those projects. Consequently, some kind of a structure which maybe the ACC can think of or someone else, that some kind of thing needs to be there at the project level to handle the project related issue, except for the financial part.
Lord, may I
Can it be on 24th, my lord?
may I bring the notice to amendments?
Suggestions if any to the proposal to the recommendations made by the London Micros
Amendments.
which are duly incorporated in our order dated 10th April 2026 may be made within 3 days. Post this matter for further consideration.
Can it be on 24th? 24th or 27th, my lord? Home buyers have to file also.
Next Monday because the urgency is there.
My lord.
Yes, yes.
There is nobody is working and we have stopped. There is an interim order.
Yes, and Manoj, may I've handed in an MA that may be registered, Manoj. So I'll put in my replies also separately.
I have passed on the amendment also, my lord.
And I may be given a copy of the MA.
Section 526. Next page. 526.
Please pass.
I have passed on the amendment, my lord, for your lordship, please.
Right, we will consider them together. We give to the amicus.
Yes, we. Amicus.
Manoj, would that MA be numbered? Which we have I have taken out an MA with E-filed, etc.
You ask your junior to file now in the registry because.
Yeah, no, we'll file in the registry. They say that because it's a disposed of appeal, they don't number it.
Permission would be required.
Without your
Permission
permission.
would be required, my lord.
The registry director to assign the number. Post this I may on the date sheet.
Grateful.
Pension may be allowed.
Malaj, I beg to appear for the state, Malaj. The file and record is here. We filed a status report. It may not be on record, Malaj. I'm carrying copies. Malaj, broadly, if your lordships will see, Malaj, the charge sheet is actually filed under the enhanced sections, Malaj, of POCSO. In fact, the enhancement happened on the very next day, Malaj, after the inquest report and postmortem. So we are carrying, Malaj, your lordships had permitted the commissioner to go back, but the Malaj ACP, the SHO are here. Original files, because the charge sheet has been filed and cognizance is also taken, Malaj. They are with the
That is what is happening, and sometimes it's quite disturbing that suddenly somebody wants to come to the court
Then you said the charge sheet has been filed.
In this case, the charge sheet was actually filed even before they came. So the date of the charge sheet here is, Malats, 3rd of April 2026. So on the writ petition does not disclose it, Malats, but the charge sheet was filed on 3rd of April 2026 and cognizance was also taken.
My lord, I have certain things to say. If you see what the status report which has been filed, on the last date of hearing, I had submitted specifically that there seems to be an attempt to shield the hospitals concerned. One, they have not served the hospitals despite your lordship's directions. They are yet to come on record. Secondly, you will find that the policemen have gone around, recorded statements of people saying this, that the child was found not breathing at that point of time. The video is speaking otherwise. Why don't they inquire into that? An SIT needs to be constituted because there seems to be a concerted effort to see to it that this is completely taken away from the record. Even now, despite the fact that there were directions from this court, and even the postmortem does not direct an inquiry towards the aspect of sexual assault. This is the manner in which these investigations have gone on. One can really...
Charge sheet has been filed under which provision?
Please, my lord.
Have you mentioned any charge sheet?
The charge sheet I have yet to see. They are yet to file that record. I'll have to look into that. But the status report which they have served on us.
Status report, we have served the hospitals also. Lordships will see para 18 of the status report, my lords. The charge sheet has been filed
104, my lords.
under section 66, which corresponds to, my lords, section 376A, 5 and 6 of POCSO Act, which is aggravated. Lordships will have para 18, my lords.
And murder and...
No, my lord. Here the issue is that when the child was alive, 2 private hospitals have the discretion to say that we will not treat you, we will not admit you,
That is not a
and the child dies thereafter.
part of prosecution.
No, that is also a part of it.
That's not a part of prosecution.
But what I am trying to say is, my lord,
Your main thrust will be against the offender who has...
no, that as well. As far as the offender is concerned, when the FIR came into place,
In the nature of, I think 357B.
no, my lord. Here, in fact, offences independently are attracted against the hospital in relation to 304. Because at the time when the child was brought there, if that aid was given at that point of time, the child would have survived. You, in fact, hasten the death of the child by not admitting the child and giving the child the treatment at that point of time, especially when there are directions from this honorable court that nobody can refuse. That is what is also bothering me. We have lost a life, and especially our 4-year-old child, because that medical intervention didn't happen.
We have,
Not one hospital, 2 hospitals, one after the other.
we have penal provisions.
Apart from that, there are penal provisions in relation to that.
We have penal provisions for the failure to record a report. Record a report at the police station in respect of a sexual crime.
Even that was not done. If your lordship sees,
Hospitals will not record it, right?
no, I am not saying that.
Let's examine according in light of your submission, which is quite distressing that the hospitals did not extend medical relief, and that would be a breach of Article 21 rights in the form of a constitution tort. With that will...
No, it would not be a tort alone, my lord.
It's what we should expect.
In a normal case where it's a situation,
Whether this would transcend to crime.
yes, it would.
What would be the offense according to you? 304.
I would say 302 at the highest, but 304 at a lesser degree. Because you are fully aware of the fact that there could be a situation where the child may not survive. You have that knowledge. And the police shuts its eye in relation to that, records statements contrary to the situation in the... I will only urge one thing, my lord. Your lordship may kindly see...
The prosecution should be against the principal accused.
The principal accused also, my lord, initially was to shield him.
Penumbular players.
I agree to one aspect, my lord. As far as that is concerned, even the FIR, initially, if your lordship sees the FIR doesn't talk about rape at all.
Line last seen together and the recovery.
My lords, last seen together, there is also.
Any, you sent the blood and the other
Yes, my lords.
fluids for DNA exam?
Yes, my lords.
And also of the accused?
Yes, my lords. The
That
report.
whether any bodily fluids of the
Yes.
accused found on the
Yes.
body of the deceased?
Yes, my lords.
If your lord,
There is one more additional.
These are the areas perhaps which are.
my lord,
There is
there are
more
two areas
focus
which are disturbing.
given. Rather than we understand your concern as a bereaved parent, but if you look at it from the perspective of investigation of the crime, it should be targeted.
So many documents, spreadsheets, videos to go through, and the deadline is tomorrow. All the
Clear investigational purposes.
Now, my lord, shall we look at it from that dimension?
Mr. Ariad,
I will take you through that dimension as well.
Yes, that is.
My friend is saying that everything was done. Kindly see that the incident happens on 16th of March. Till 17th of March, 3:30 in the morning, the next day, around 18 hours of difference is there in even getting the first information report in place. And what does my friend, can I?
3:30 in the morning, my lords. It's not.
3:30 in the morning is what I am saying.
It's 3:30 in the morning.
Incident is happening at 6:30 in the evening. The aspect of the child having been brought dead is recorded in the hospital at 21:55 hours. Why is it that the FIR is coming into place at 3:30 in the morning, my lord? Look at the time period which has elapsed. And the FIR which is coming into place is an FIR which is coming into place only in relation to 302. There is no mention in the FIR of any of the offences of aggravated assault or in relation to rape, which is what I pointed out on the last date of hearing.
I was just going through the status report.
Please, your lord.
So that is just examine the charge sheet.
Very well. Let them.
Because we would first like the victim's family's full satisfaction. The law will never be able to really to our satisfaction, its moment will be fall short of unless the victim's family is satisfied. So, but at the same time, in our over anxiety, constituting SIP may unnecessarily may not further delay the proceeding. From that angle, you just examine.
My lord, I have only two concerns. One, the day the report is tried to be lodged by the father, he gets beaten up at the police station.
See,
a daily wager, a laborer, this is the manner in which they treat him. And now they are hounding him, saying this, that you have gone to the Supreme Court, please withdraw your petition. This is the manner in which he is being treated.
Did he receive this sort of a threat?
Yes. And he has been shifted from Uttar Pradesh to Delhi now.
The trauma and torture the family has undergone.
Please, my lord.
The trauma, the torture,
Yes.
the agony, and the kind of this pain.
The child and the hospitals don't treat the child, my lord. How can we in a country like ours even imagine a situation like this?
That's why we want that first of all, because they know everything that how the occurrence at the entire.
Why aren't they accepting the video recording, my lord? There is a video recording of the child where the child is seen to be alive. Why don't they take it on record?
They are referring to a video recording also. That's why we are just pointing out.
It's right here, my lord. I can give it to you. I can pass it across.
They are referring to some video recording. Is it the same thing or is it different
Of
thing?
my child, my lord. I am carrying my child.
Examine it. You are the best. With the assistance of the parents.
But my lord, they should first and foremost take that on record. They refuse to take that on record. They are going by the assumption that the child is dead at that point of time. That is the whole problem. And my friend says that no, everything is okay. Nothing is okay according to me. It is highly disturbing, my lord.
Please try to understand what we are trying.
Yes, my lord.
Now they are coming out with a charge sheet which refer to some.
I will look into that, my lord. Tell them to give me a copy.
Recording, etc. They are referring to. which video recording are they referring? Is it the same or different, or is it only a?
I will have an examination of that.
Only a kind of a, just to.
And I wash. Your Lordship, I tell them to give us a copy. I will look into it and I'll get back.
Just examine, as a victim, you are entitled to a copy of charge sheet. You go through it.
Very well, my lord.
After that, if you feel that there are some gaps which have been deliberately left, or because of their negligence it has been left, we would like an SIT to do so.
Very well, my lord.
But if suppose charge sheet has been filed, then there is a different kind of monitoring required. Then we will evolve that mechanism.
Very well, my lord. I will assist you on that. I will assist you on that.
They are exonerating the hospitals. Or
No, I'm not saying that. My only.
Those issues will be separately examined.
Very well.
We are not closing the issue.
Very well, my lord. My anguish is that a child is not getting treatment when the child is in this kind of a state. Maybe the child would have been alive today and we would have had better evidence. We have to look at it from that aspect too.
Now, where are the two hospitals?
I am representing respondent 4, my lords. And Joseph.
Lordship, I am appearing for R3. I am appearing for R3, Your Lordship.
R5?
R3, Your Lordship.
R3. Yes. Say in purported compliance of order dated 10th April 2026, a status report has been filed. Is it signed by someone?
ACP.
The Additional Commissioner of Police, my lords. At page
Each page is
21, my lords.
Has been filed by some assistant, has been filed by an assistant commissioner of police. Police Commissioner Ghaziabad. The status report reveals that charge sheet has been filed. Before adverting to the various issues that we have briefly flagged in our order dated 10th April 26. We direct the police authorities to supply a copy of the charge sheet to the victim's family.
Along with that CCTV, my lord, which they are, the coverage that they are saying. So that I will be in a position to compare. Because my reading is that it is a CCTV of the location which they are trying to show.
That's right, my lords. It's the CCTV.
Yes, so it is not that video recording which I am trying to give to them. Why are they taking that?
If there is any recording available with the my lords complainant, we can do additional.
He has been trying to give it to them from day one. They are refusing to accept it. This is what I am saying.
There is a CCTV footage.
Yes, my lord.
If they are relying upon.
That CCTV footage is, my lord, at the time when they went to the site.
Which is the accused taking the victim, my lord?
The accused has gone and effected a recovery where they shoot the victim on the accused on his legs. It is of that period that they are trying to give. But this relates to the time when the child was recovered and the father had taken the child from there on a motorbike to the two hospitals.
Accused of look into the documents and electronic material they supply to you, and then you make a response to us.
Very well.
So that
Very well, my lord. All I am saying is let them give that CCTV record to me.
yes, madam, you can also look into it and
closing
assess.
I agree.
Necessary further investigation can
Well, that's what I'm respectfully submitting. If there is anything additional, we will carry out additional my lords investigation.
Victim's family. Post the matter on date for further consideration. Meanwhile, the House number 3 and 4 hospitals are also directed to file their respective affidavits. In response to the allegations made against them. No further reason in this regard, no further time in this regard be granted. First, the matter for further consideration and consideration.
My lords, would your lordships desire us to carry out further investigation on material that is supplied by?
No, who will carry out that further investigation is the.
That is the issue.
So your lordships will hold our hands, my lord.
That we have exonerated them, they are conducting.
I bow down, my lord.
Under serious doubt.
I bow down.
We have serious doubt on their bona fides, the way they have acted. But today we don't want to comment because it may, unfortunately, if we comment to anything and charge sheet is found all right, then it may prejudice the party. So therefore, we have to be very careful in observing anything.
So, my lords, we'll hold our hands now, my lords. So, my lords, we'll hold our hands now. Whatever investigation we have done so far, that we have brought the certified copy of the file, my lords. Otherwise, if your lordships desire the original file, it will have to come from the court, my lords. The court has given us the certified copy. Otherwise, court has taken cognizance.
No, we are not insisting on the original file. You can give us a certified copy. We have no issues.
Yes, to my colleagues, I'll give copy of the certified.
Give us a copy of the certified. That is good enough.
Title to these copies.
Yes, my lords, they could have taken it, my lords.
No, I happen to be the complainant. The entitlement is to the accused.
No, entitlement is to all. We have supplied copies for you also submitted in.
207 is in relation to the accused, not to the complainant.
We'll give you, sir.
रुक जाओ भी अभी ये लाइव वाला देखना भाई तो
Next Monday.
Next Monday, because I don't think your lordship is free in the